Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is all about the protection period in the buyer's brokerage agreement. Please watch the video I did on the protected period in the listing brokerage agreement, and today's video is all about that same concept but in the buyer brokerage agreements in the Georgia Association of Realtors listing agreement and the RE forms, not listing agreement, buyer brokerage agreement and the RE forms buyer brokerage agreement. So the first thing I want to say is before continuing on and getting into the actual agreements is please refer, or let me say refresh yourself on the laws governing buyer brokerage here in the state of Georgia. And the reference is Official Code Georgia Annotated. It's our law. It's part of our license law. And it is OCGA Title 10, Chapter 6A, Brokerage Relationships in Real Estate Transactions, lovingly referred to as our Beretta laws. So let's dive in, shall we? The first thing to consider is just generally speaking, that when a buyer chooses your broker with whom to work to help them buy a house here in the state of Georgia, they can choose to work with your broker and you as an affiliated licensee of your broker as a client. In order to do that, it must be in writing. In Georgia, the client relationship is contractually driven to be a buyer for the conveyance of real property. And that is done through our buyer brokerage agreements. So in that document, it describes the client relationship, the duties of the buyer to the broker, the duties of the broker to the buyer, so forth and so on. But specifically what I want to talk about is the protected period. So after the expiration or termination of a buyer brokerage agreement, there is a paragraph in there that talks about the broker's commission being protected. Now, let me start off by saying that the intent of the protected period in both the GAR form and the RE form is to protect a broker's commission. If the buyer, while they were engaged in a buyer brokerage agreement with you, and they saw a house, wrote an offer on a house, or you introduced them to that house while they were with you as your client, the brokerage agreement ends, and then they go back and purchase that home. Your broker is entitled to commission on that per the protected period. So let's take a look at the actual agreements and let's see what they say. So the GAR buyer brokerage agreement is Form F-110, and it is the exclusive buyer brokerage agreement. Now, the first thing I need to bring to your attention is in paragraph B1, it states when the buyer signs, it states the buyer warrants that the buyer is not a party to any other current exclusive buyer brokerage engagement agreement, that all previous exclusive buyer brokerage engagement agreements entered into between the buyer and any other real estate brokerage have either been terminated, expired, or have not been renewed. And then in that same paragraph, it goes on to say that any agreement to terminate this agreement or other subsequent agreements between the parties must be done in writing and signed by the party. So when a buyer signs a buyer brokerage agreement with you, they are stating that they do not have another signed buyer brokerage agreement with another broker. Now, the protected period is all explained in paragraph 7, protected period. And what it says is if during the protected period, and in the first paragraph A, you fill out how long that protected period is. And that is protection for the broker's commission after the end of this buyer brokerage for a certain number of days. And it states that in the event that during the protected period, as that term is defined below, following the termination or expiration of this brokerage agreement, the buyer purchases, options, contracts, basically goes under contract for or purchases a property which during the term of this agreement was submitted to, identified, or shown to the buyer by the broker, or for which the broker provided information about to the buyer. Then, notwithstanding any provision to the contrary contained herein, the buyer shall pay the broker at closing or the commencement of any lease the commission set forth above. It goes on to say that the protected period shall refer to the period following either the expiration of the agreement or the date the agreement was terminated upon mutual written consent between the buyer and the broker. And if it is terminated by the buyer without the express written consent of the broker. In other words, if the buyer fires you or unilaterally terminates, that in essence is a breach of the contract. Then the protected period is the time frame that you had allocated in that section A, the number of days agreed upon, plus any additional days that were remaining on the buyer brokerage from the time it was unilaterally terminated by the broker without the broker's express written consent. And again, that is GAR form F510, 5110, protected period. In the RE forms, it is the exclusive buyer brokerage agreement is RE 150, and it has the same verbiage. In this buyer brokerage agreement, it's under paragraph 3, other relationships. And it specifically states that the buyer, that should the buyer contract for a property, write a contract, go under contract, close, purchase a property without the services of the broker to make direct purchase, exchange, lease, option, so forth and so on, of the property within X number of days, so you fill in the number of days after the expiration date or any extension thereof, for a property that was offered during the term of this agreement or any extension thereof by the broker, by the buyer, or anyone else. The buyer, again, agrees to pay the broker the commission at the same rate that had agreed upon in the buyer brokerage agreement. It's agreed and understood that when the buyer enters into an exclusive buyer brokerage agreement for a property with a subsequent broker, the broker's commission rights remain enforceable, and the broker, meaning this broker, shall be entitled to a commission. So it's a little confusing, and it's definitely different from the listing agreement protection period. So in the listing agreement protection period, the listing broker is protected for commission if the seller sells to anyone within that protected time frame up until the point that that seller lists their property with another broker. If it's the day after, it doesn't matter. The time, if a seller lists a property with another broker, there's no protection for commission for the current broker whose listing agreement had expired or terminated, so forth and so on. However, in the buyer's brokerage agreement, the buyer's broker, their commission is protected, even if the buyer signs another buyer brokerage agreement with another broker. But what's protected? Not the buyer in total. What's protected are the properties that you brought to the attention of the buyer, showed the buyer, wrote an offer on for the buyer, provided information about for the buyer. So then you're sitting here asking yourself, well, gosh, is that a blanket protection? Because nowadays, through a lot of our technology, buyers are getting information about properties while they are in your buyer brokerage agreement through the internet, through online, through listing book, through the MLS automated services. So it behooves you as a buyer's agent to make sure that you are aware of what properties are being brought to the attention of your buyer and making a note of those and going further and having a discussion with your buyer about a property that would actually definitely meet their needs. So even though it sounds like it's a blanket protection for every property, the intent is for the properties that you brought to the attention of your buyer while they were working with you as a client. Now, let's go a little bit further. It's a little bit different with buyer brokerage agreement. If you are a broker, if you're an agent, and a public buyer comes to you and asks you to help them buy a house, well, now there's a little bit more duty that you need to do to protect the buyer so that the buyer does not owe potentially a former buyer's broker a commission. So what does that mean? Basically, if a buyer comes to you and says, and you say, are you working with another agent? And they say, nope, not anymore. And you say, well, had you signed anything with another agent? And if they say, I don't remember, that's what we like to call a clue. That means they probably may have signed something. Or if they say something like, well, I fired my other buyer's agent. They were horrible, or they didn't listen to me, or they didn't show me, or blah, 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 whatever. If you hear the word fired my other agent, then that gives you, or if you find a property that they want to put an offer on and they're like, I've already seen it, that gives you reason to believe they may have been engaged in another relationship, client relationship with another broker. So now let's look at what license law says about that for you as buyer broker number 2. So license law says, let me find that and I will tell you what that says. License law says, and this is GREC rule, it's in Beretta too, but it's also in GREC rule 520-1-.10 under the handling of real estate transactions. It is a license law about obtaining a brokerage agreement if you have reason to believe that the person has an outstanding brokerage agreement with another broker. Why would it be a potential license law violation on you? Because you could be incurring additional costs to that public buyer. So if the buyer says, again, that he has fired the agent with whom he or she had previously worked, then perhaps, that buyer has signed something and may still have the obligation to the other broker financially for some commission. Also, an agent telling an agent via email or phone or text that they have fired you or are no longer working with you does not necessarily mean, like if they say, yeah, I fired him by text or I sent an email. That does not necessarily mean that that buyer has actually mutually terminated that buyer brokerage agreement and is under no further obligation to that former broker financially. So they may still owe them commission. So, also, even just with the buyer brokerage agreement itself, you have no idea what special stipulations may have been in the brokerage agreement. This extends to listing agreements too, but for the purpose of this video, we're talking about buyer brokerage. You have no idea what special stipulations were or were not included in broker number A, in broker number 1's buyer brokerage agreement that this buyer may or may not have signed. So, based on license law and some of those issues we've just talked about, the agent, you need to tell that buyer that they need to really have a talk with the current broker just to ensure that that relationship, that client relationship, has been terminated in writing and that the buyer is free to work with another broker. So, in other words, if you have reason to believe that a buyer, again, or seller may have an outstanding brokerage engagement with another broker, you need to confirm, you as the agent need to confirm with the previous broker that the public person, the public buyer, has actually terminated the agreement prior to your signing a buyer brokerage agreement with them. So, again, for a seller, it's a little bit easier because you can check it out in the MLS services if it was listed and see if it was expired or not. For a buyer, you would want a copy of the buyer brokerage, a copy of the termination agreement of the buyer brokerage agreement with the former broker, because the buyer should have it, because you guys also know from license law, public gets a copy of everything they signed. And or you should email the former broker that says blank, the name of the public buyer, has approached me for representation regarding real estate uh, transactions. I have reason to believe that the buyer has terminated the brokerage agreement with your firm in compliance with license laws OCGA 434025B13 and OCGA 43-4025B26. Please confirm that please confirm this termination. If I do not hear back from you within 24 hours, I will accept this non-response as confirmation of the termination of the buyer brokerage agreement with your firm. Now, that is going to protect you and protect your license and keep you in compliance with license law with respect to having a buyer sign a buyer brokerage agreement with you if you have reason to believe that they have had a previous, maybe involved in another previous buyer brokerage agreement. If the buyer refuses to give you their former broker's name by, oh, I just don't remember, I lost their contact information, then I strongly suggest you get that buyer to write that in writing. And you would just put something in writing that says, I, put the public buyer's name, affirm that I have no written obligation to work with any other broker for my real estate needs. All parties agree to indemnify and hold agent and brokerage harmless from and against all claims, injuries, suits, damages arising out of the party's answer to the above choices. And then you would have your public buyer sign that and keep a record of that. So again, the protected period in the buyer brokerage agreements is just a tad different than the protected period in the listing agreements. Also there's a little bit of a different overlay of laws that impact your interaction with the buyer with respect to buyer brokerage. So I hope this contract tip helped you out. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.